I just wanted to say briefly that this obligation to provide software updates does not mean that that the consumer has a right to an update in the sense of an upgrade to the next product. This is not what is meant by that. And also, the consumer is not forced to install the update, but there can be consequences if he doesn't install the update. And if that happens, the trader is not liable for any damages, for example, due to the lack of updating, given the instructions were correct. You can skip to the next page. Yeah. This slide is just to show you that all the 4 groups are covered with one or the other directive, because even though the scope of the directive is different, they both contain that obligation. So all the digital elements are covered, whether it's just a digital element or if it's a good with a digital element essential to function. You can skip to the. So what happens now in the AMCO directive is that the contractual information I was talking about, they now also require information on sustainability aspect. So, quote, the trader shall provide information for goods with digital elements, digital contents and services. The minimum duration which the producer or the provider provides software updates. And he has to give a specific time, and that specifies that vague term, reasonable time to expect. So consumer know this is the period in which I will have these updates. Apart from that, the other technique is to amend the unfair commercial practice. There are relevant behaviors added to the so-called blacklist. I'm quoting. So withholding information from the consumer about the fact that the software update will negatively impact the functioning of goods with digital elements or digital contents or services. And also presenting a software update as necessary when it only enhances functionality factors. So these 2 additions to the blacklist show that the directive recognizes that software doesn't work isolated. So a software update will not just solve a problem, but it can also have influences on other parts. So for example, the software update helps to calculate faster, but the battery runs slow. So this leads me to my concluding thesis. The changes to the obligation to provide updates, in general, they are in line with the EU typical information ideal. This applies also to the extension into unfair competition law. And the further development of existing aspects of sustainable consumption is just as possible within the framework of Green Deal as the creation of new instruments. We see here, we didn't create a new instrument, but we just developed it and specified it. And in addition to sustainability as expert, further development can also include practical facets, this differentiation of the updates to promote consumer interests. Thank you very much for your attention.
Thanks a lot. Catherine, you were our exchange student 10 years ago, and we are very glad you are again here in Porto Alegre. This moment as a doctorand aus Heidelberg. Well, let's take the word to Ana Paula Arzt, professor and at URGS postdoc. You have the floor.
So initially, I'd like to congratulate the audience present here today. the professors participating in this panel with me, and the CDA and the AD for holding the workshop of the Brazil-German Research Network in Consumer Law. I'd like to a special greeting for Professor Dr. Claudia Lima Marques, great creator of this event, and to the German teachers present here. I'm very honored to be able to learn from you. So my speech is about sustainable consumption and its effects on Brazilian consumer law. Okay. Okay, thank you. In the Brazilian case, the option of codifying consumer norms was taken by the National Constituent Assembly. So the Brazilian Constitution guarantees consumer rights as a fundamental right, it's important to say, and established that the state shall promote in accordance with the law the defense of consumer, and is also a principle of the economic order here. The legislator also consecrated the creation of a code of a normative nature which would guarantee the protection established in the Constitution and the duty of the state to protect the vulnerable person of rights in the market, the consumer. The constitutional text recognized that the consumer could not be adequately protected on the basis of sparse, often contradictory or incomplete laws. It therefore adopted the concept of codification with a general and systematic framework for regulation the consumer market. So protection is not given to the consumer, to the relation of consumption, but for the consumer, the new postmodern subject of rights, a person of rights. Brazil is a civil law country, and as such, is written law is an important and essential source to guide society and the rule of law. So, what's the main innovations brought to Brazilian law by the Consumer Protection Code in Brazil? There are many, like the regulation of the advertising as a binding offer and the fight against misleading and abusive advertising, the regulation of service contracts, establish a dialogue of source in Brazil, o diálogo das fontes, establish a theory of quality of products and services, regulate adhesion contracts and debt collection, consolidate the principle of good faith in relation between suppliers and professionals and consumers, harmonize the action of negative databases, privatized providers of public services and providers of products and services in general. We will now explore the theory of quality incorporated into the Brazilian Consumer Protection Code. So, the theory of quality in Brazil brought for Minister Antônio Hermann Benjamin has two distinct aspects: the protection of the consumer assets by dealing with quality defect due to inadequacy, and the protection of the consumer's health by dealing with quality defects due to insecurity. Therefore, the theory of quality aims to protect the physical and physical safety of the consumer and the economic safety of the consumer too. So, I am now list some articles, important articles that deal with these norms relating to theory of quality. The Article 8, products that state that products and services placed on the consumer market shall not entail risks to the health or safety of consumer, except that those considered normal and foreseeable. Article 12 and 14 of the code provide respectively for the supplier's liability for product and service defects. And paragraph 1st of the Article 12 that states that a product is defective when it does not offer the safety that is legitimately expected of it, taking into account the relevant circumstances among some circumstance relevant that is listed in law. So, Article 12 of the code links the product defect to the lack of safety of the product or service, like ability to cause damage to the consumer's health. So the notion of a product defect is directly related to that consumer accident and is linked to the breach of consumer expectation as to the safety expected of the product or service. It should be noted that the theory of quality has been consolidated and applied by the Brazilian Superior Court of Justice in various cases, such as the adaptation of products to technical standards and the objective of regulation, the industrial quality and conformity of products placed on the consumer market, the quality of services, cases with great national repercussions, such as the explosion of a gas cylinder in a shopping center and the attack of lions on a child watching circus performance, among many others. The jurisprudence of Brazilian Superior Court of Justice recently directly links quality to durability, combating non-durability as a defect. And the Superior Court has already ruled on the problem of planned obsolescence. However, the theory of quality must adapt to the legitimate expectation of our time, where the durability and the repairability of products and services become a condition of the quality and safety of products and services. So let's see. So here, the sustainability we can understand as a new paradigm for products and services. Sustainable consumption is defined as the use of services and products that meet the basic needs of all people and bring improved quality of life while reducing the use of natural resources and toxic materials, waste production and pollution emissions throughout the life cycle without compromising the needs of future generations. So the sustainable consumption has been in the last decades an objective since Agenda 21, the document that resulted from Rio 92. And in chapter 4 points out that the greatest cause of continued deterioration of the global environment is the unsustainable pattern of consumption and production, particularly in industrialized countries. So the emergence of environmental problems such as pollution, major environment disaster, and climate change has led to a redimensioning of our way of examining the law, since it affects the explosion phase of legal problems. So now we can understand the law and this new paradigm, environmental paradigm, which recognize nature as a subject of rights and operates by imposing certain limitations on individual rights and must adapt to a sustainable paradigms in environmental matters. In a recent survey, 30,000 consumers in 11 countries and territories were interviewed, and it was found that since COVID-19, many consumers, more than 50%, have become concerned about environmental and social issues, with many moving from indifference to an active stance on sustainable attitudes. So, more forcefully, as of 2015, several international documents carry lines to promote sustainable consumption, such as United Nations Guidelines for Consumer Protection, the 2030 Agenda for Sustainable Development, Paris Climate Agreement. These international and national documents reinforce the need for a transition in the quality parameters of products and services. So, consumer interest in environmentally friendly products and services has increased, and manufacturers have invested heavily in marketing and selling green products, not always actually adopting environmentally sustainable practice in the production process or in the final product. So, we analyze here a new parameter for assessing the quality and safety of products and services in these international and national documents, as I mentioned before. So the main characteristics of products and services in line with new consumer and even social expectation of quality and safety, taking into account environmental and circularity aspects like durability, repair, availability of spare parts, and recyclability, becoming important categories that can be assessed when checking a product and a service. So how these international documents and this new environmental paradigm we can understand in Consumer Protection Code in Brazil. The code incorporates its environmental concerns in advertising and in abusive clauses. Recently, the update of the code through law 14,181 has already included in the principal rule of Article 4 a new principle that promotes action aimed at environmental education of consumers, provided for the bill that we'll see the next slide. So the new issues of the consumer society in Brazil, the environmental problems, are precisely one of the topics of the Brazilian Federal Senate bill, currently being studied by the Chamber of Deputies. The law project 3514 of 2015, which aims to update the Consumer Protection Code for a digital and sustainable consumption. So what are the main innovations foreseen in this bill on sustainable consumption? First of all, introduce in Article 4 of the code the protection of the environment as an objective of the national policy of consumer relations and its incisions, adds the encouragement and promotion of sustainable production and consumption as principles in order to ensure better living conditions and promote the economic development and social inclusion of current generation without compromise the needs of future generations. Updates Article 6 of the Code, which includes environmental, truthful, and useful information in the category of basic consumer rights, and instrumentalize the right to information provided for in law that established the national solid waste policy in Brazil. Introduce Article 10A. This refers to the norms of Article 8, 9, and 10, which deal with the quality of products and services and the prevention and repair of damage. In this sense, it adds preventive and precautionary rules also to the risks of products and services resulting from environmental impacts, in a lato sensu preventive measure of damage. And the last one, Article 39, deals with the prohibition of abusive practice, and its subsections list the types of this practice that are prohibited by the code. The bill updates these subsections, adding subsection 14, and considers as an abusive practice the offering of a product or service with potential negative environment impact without taking the necessary preventive and precautionary measures. And final considerations, Brazil, as one of the largest consumer markets in the world, must create a mechanism to inform, raise awarenesses, and educate consumers about the sustainability of the products and services that is addressed in bill. The climate change we are experiencing call for urgent action on sustainable consumption, consumer education and information, waste management, lifestyle changes, and more sustainable and resilient cities. The approval of the bill will be an important step in the promotion of sustainable consumption in Brazil. Thank you very much.
Thanks a lot, Ana Paula, for your presentation. And now we will have Dr. Christine Meyerhofer, habilitant in München. Feel free.
Thank you very much. It's great to be here in Porto Alegre for the first time. Thank you to everyone who made this possible. And yes, today I'm going to talk about the right to repair in the European Union. And now we will wait for the slides.
Which one?
Right to repair. I don't know. Do you have my presentation?
Slides are saved.
Ah. No. Maybe could you pass me the keyboard? Thank you. I also have an USB, if that helps.
Bem, aproveitamos o momento para saudar os colegas professores da casa, o professor Marcelo Schenck-Duque, a professora Maria Cristina Pezella, nos alegram com as suas presenças. Também de Tucumã, o professor Esteban Nader, do German Desk, e os já nominados professores alemães, que para nós muito honram terem escolhido Porto Alegre para a sede desse evento, professor Marcos Arzt, professora Caroline Meller-Hanich, professora Beate Gisel, coordenadora dessa rede na Alemanha, e também o professor Thomas Müllers, que nos brilhantou essa manhã com a apresentação principal. Agora sim, encontramos a palestra. Perfeito.
Thank you. Okay, perfect. I think just some effects got lost, but it will work fine. Okay, my talk will focus on the new Right to Repair Directive, or Repair Directive for short. If you want, you can access the directive via this QR code. The Repair Directive was adopted in the European Union in June 2024 and must be transposed into national law by 2026. As you may know, unlike EU regulations, EU directives do not have a direct effect in national law, but must be transposed by the member states into their respective national order. The Repair Directive, as you can read, provides for common rules promoting the repair of goods by establishing a new right to repair. Besides, and that's like highlighted here in red, it also amends some older instruments, especially the so-called Sale of Good Directive of 2019. We just heard about it. And this directive already contains rules on the liability of the seller towards the consumer in the event of a lack of conformity, and an older right to repair. The Sale of Good Directive of 2019 replaced the old Consumer Sales Directive of 1999. I will start this presentation with some general remarks on the Repair Directive. The Repair Directive establishes a new right to repair of the consumer against the manufacturer. This is the second point. The Repair Directive also modifies the old right to repair against the seller under the Sale of Good Directive. We will explore this old right in a third point. And then, as a fourth point, we'll briefly look at some other mechanisms of the Right to Repair Directive, and then I will conclude with some discussion points. So I'm beginning with some general remarks on the right to repair. The right to repair aims to promote repairs. Why? According to Recital 3, repair should result in sustainable consumption. In general, it is more sustainable to repair a defective good instead of throwing it away and buying a new one. So the promotion of repairs is part of the Green Deal of the European Union. We've already heard about the Green Deal. And the overarching goal of reaching climate neutrality, this overarching goal of the Green Deal, it can be split up in several sub-goals, as you can see here. And one of these sub-goals is this goal to reach the circular economy. And the right of repair is part of this idea to reach circular economy, and it's also only one piece in the bigger puzzle of European sustainable regulation that's important to keep in mind when dealing with the right to repair. And this also becomes clear when we consider the conditions that must actually be met for repair to be carried out. And here, 4 basic requirements can be identified. First, the good must be repairable. Secondly, the consumer must know whether the good can be repaired. Thirdly, there must be a repairer, someone who is prepared to repair the good. And fourthly, the consumer must be willing to have the good repaired. Although the repair directive plays a certain role for all 4 conditions, the focus is on the last 2, 3 and 4. The directive establishes obligations for manufacturers and modifies the existing obligations of sellers under the Sale of Good Directive. And in addition, the directive is intended to create incentives for consumers to have repairs carried out. By contrast, condition 1 is mostly determined by eco-design law, especially by the new eco-design regulation. This regulation aims at an extension of product requirements about repairability. And regarding condition 2, the Empowering Consumer Directive, which we have already met this afternoon, plays a major role. If we now look at how the legislator addresses the 4 conditions, it is noticeable that the first 3 conditions, 1, 2, 3, are to be secured with binding requirements and obligations of the actors of the supply side. By contrast, the 4th requirement, which relates to the consumer sides, is based on incentives rather than obligations. We've already heard this morning on the idea of nudging. It's a bit the idea here as well. The consumer should voluntarily choose a repair. And this, of course, raises the question which criteria are decisive for the consumer decision. And here, recital 4 of the directive mentions in particular economic convenience, durability, availability, the proximity of a repair service, and finally the time required for a repair. Keep these criteria, which you can see here highlighted, in mind. We will meet them again in the course of this presentation. The criteria actually correspond to the findings of different studies. In particular, the price of the repair seems to play a major role in the consumer's decision. For example, in a survey published in 2020, almost 80% said that manufacturers should be required to make it easier to repair. However, 2/3 of those who said they wanted to promote the repair, they said they supported this only if the cost of higher repairability was not passed on the consumer. And other studies found that repairs were also often considered too time-consuming or too complicated. And with all, if we look at all these studies, we can suggest that consumers are usually moderately sustainability conscious. They want to do something for the environment, but at the same time, they are very economical and convenient. And all this, of course, needs to be taken into account when setting incentives. Let's now take a closer look at the rights of a consumer who bought a good which then appears to be defective, for example, a washing machine. First of all, we must make a fundamental distinction, which has already been mentioned in my outline. If the defect constitutes a lack of conformity, this is the left side, and triggers the seller's liability under the Sale of Goods Directive, the consumer has a contractual right to repair under this older directive. The repair in this case must be carried out free of charge. This free repair is generally appropriate. We have seen that the price is indeed a decisive obstacle, and besides, the free repair in this case is justified because the good does not conform to the sales contract. If, however, and this is the other side, the defect is outside the liability of the seller, for example, because it appears after the expiration of the liability period, or because it stems from a mistreatment by the consumer, the new right to repair that was firstly established by the new right to repair directive applies. In such cases, as you can see, the repair is not free. It's not free of charge, but the consumer must pay for the repair. And again, in principle, this possibility of the repairer to charge a price for the repair is also appropriate. Certainly, yes, the price is a decisive obstacle, but if a defect lies outside the liability of a seller, a free repair is hardly justifiable. It could first create negative behavioral incentives for the consumer. The consumer would no longer have a reason to handle the good with care if he could always demand repair for free. And in addition, the obligation to repair for free would, of course, place a considerable burden on the person that must repair. And this brings us to the next question. Who is actually the person that must repair the good? Here, too, the fundamental distinction is important. In the event of a defect within the liability of the seller under the Sale of Goods Directive, again, this side, the right to repair exists against the seller in accordance with the Sale of Goods Directive. Otherwise, the other side, there's a right to repair against the manufacturer. These choices, seller, manufacturer, they have benefits and drawbacks. It seems that in general, it is easier for the consumer to contact the seller as the consumer has already purchased the good from this person. On the other hand, these sellers, they are often not able to repair the goods themselves. They are dependent on the cooperation of the manufacturers, who is usually in a better position to repair the good. At the same time, manufacturers may be harder to reach for the consumer. They are maybe the less obvious point of contact for the consumer. So as you can see, benefits and drawbacks. However, I wonder if generally this distinction between two rights to repair of the consumer against two different persons may not cause difficulties in practice. First, I wonder whether the consumer can sufficiently distinguish between the two categories of defects, between the two rights of repair. The distinction may be easy if the liability period has elapsed when a defect becomes apparent. However, as long as this period has not elapsed, it may be difficult for the consumer to assess if there's a free right to repair against the seller, or if he must go and see the manufacturer for repair which he has to pay for. And second, the distinction also seems cumbersome if a good may have several defects, and some are within the liability and others outside the liability of the seller. In principle, in such cases, some defects must be repaired by the sellers and others by the manufacturer, which does not seem to be very efficient. Therefore, one point we could discuss later, which you can see in this bubble, is the question of whether maybe a one-stop solution would be preferable. There are different possible solutions of such a one-stop mechanism. One could, for example, argue for an action directe on the French model, which would allow consumers to exercise their right to free repair not only against the seller, but also against the manufacturer. As a consequence, the consumer would then always be able to take action against the manufacturers for all defects. Besides, it would also be conceivable to create a chain of rights to repair. The consumer would then always have a right to repair against the seller, and to enable the seller to fulfill this obligation, the seller would have a right to repair against the manufacturer. So let's now have a closer look at these two rights to repair. And we will start with the new right to repair against the manufacturer, which was newly introduced by the new Repair Directive. This new right to repair is laid down in Article 5 of the Repair Directive. As you can see, it does not apply to all goods and defects, but only to the extent that repairability requirements are laid down for the good and other legal instruments. Again, remember the puzzle, there are many instruments of the European Union which somehow work together. Such requirements currently exist, for example, with regard to washing machines and mobile phones. And the cases will probably soon be extended on the basis of the framework established by the new eco-design regulation, for example, to textiles and furniture. This restriction aligns the right to repair with eco-design law, which may appear good, but I think it is questionable whether it is really necessary and appropriate. Other goods may also be repairable. For example, it is doubtful if there will be a repair obligation for bicycles in the near future. The restriction is actually intended to protect the manufacturer, but as we will see, manufacturers are already sufficiently protected by other mechanisms, that is the objection of impossibility and their right to charge a price for the repair. The right to repair, this is the next point, is unavailable if the repair is impossible. Impossibility means factual or legal impossibility, mere disproportionality due to a high cost of a repair is not sufficient. This objection of impossibility could, one could think, contradict the availability of repairs. It may carry the risk when manufacturers design the goods in an irreparable way to avoid the repair obligation. However, this objection is flanked by other rules that aim to improve this availability. For example, eco-design law sanctions the violation of repair requirements in different ways. The new eco-design regulations provides for penalties and also allows consumers to claim compensation for damages resulting from non-compliance. In addition, repairability is a requirement for conformity under the Sale of Goods Directive. So manufacturers must fear redress claims from sellers if the good is not repairable. Besides, the repair directive itself provides that the repair obligation can also be fulfilled by the manufacturers by subcontracting repairs. So the lack of an own repair shop does not justify refusal. Furthermore, Article 5.6 in principle prohibits manufacturers from hindering repairs through contractual clauses, hardware or software techniques. And last but not least, Article 5.7 prohibits to refuse the repair on the sole ground that a previous repair was carried out by another person. So all in all, as we can see, there's a considerable incentive for manufacturers not to obstruct repairability, and the hurdles for the impossibility objection are also high. If there is a right to repair under the repair directive, the repair must be carried out free of charge or at a reasonable price. You see, it must not necessarily be free, but can be charged with a reasonable price. And it must also be carried out within a reasonable period of time. In general, it is convincing to limit price and time. We have seen that price and time are essential criteria in the repair decision. However, these requirements, reasonable, are very vague, of course, so that it could be doubtful if they can make a difference regarding the economic convenience and the time required. But again, these rules are flanked by other rules. Article 5.4 obliges manufacturers of spare parts and tools to stipulate reasonable prices. This can also make repairs cheaper for the consumer. Article 5.5 asks for information about typical prices, and Article 5.8 makes it clear that consumers can also turn to repairers who are not obliged to carry out repairs. The idea behind these provisions is to encourage competitive pressure that could lead to acceptable prices. Article 13 of the Repair Directive then obliges member states to take support measures, which may also include financial support measures for repair, such as repair bonuses. In this respect, some projects already exist in Europe, which seem to be quite successful in promoting repair. However, I think keeping prices low is probably one of the biggest challenges associated with the right to repair, and might possibly be another issue for our discussion. As far as time is concerned, Article 5.2 provides that the manufacturer may provide the consumer with a replacement product during the repair. This could maybe make a possibly longer repair time more convenient. However, this is not an obligation. The manufacturer is only authorized to make this offer. So let us now deal with the second right to repair, the older right to repair against the seller. This was not newly established by the Repair Directive, but only modified. In the event of a defect inside the liability of the seller, the consumer has a right against the seller to have the goods brought into conformity by a repair. This follows from Article 13 of the Sale of Goods Directive. The prerequisites are, I now simplify a bit, that the good does not conform to the requirements of the sales contract at the time of delivery, and that the lack of conformity becomes apparent within 2 years of delivery. Furthermore, the repair must not be impossible or disproportionate. The repair is then free of charge and be carried out within a reasonable time and without any significant inconvenience. This all sounds good in principle. The problem here is that the consumer has a choice. As you can see here in the red bubble, The consumer can also opt for a replacement instead of a repair for the delivery of a new good. And this option, of course, can be very attractive for the consumer as they receive a brand new good and usually in a shorter time. The original proposal for a repair directive planned that the repair would, by contrast, be obligatory if the costs for a replacement are at least equal to the cost for a repair. However, this idea would have led to a restriction of consumer protection and could not be implemented in the final directive. Today, instead, it is only provided that if the consumer chooses the repair and not a replacement, the liability period will be extended by 1 year. So as a rule, the buyer has no rights if a defect only becomes apparent after 2 years. In the case of a repair, this period would be extended to 3 years. This should create an incentive for the consumer to have the goods repaired. However, I think it is questionable whether this incentive is really sufficient. Another question I don't have a final answer to: how attractive is an extended time limit really for the consumer? Does 1 year make such a big difference? It should also be borne in mind that if the delivery was made a long time ago, it becomes more difficult to prove there was actually a lack of conformity at the time of delivery. There's an Article 11 of the Sale of Goods Directive that provides for a certain presumption, but this presumption does not apply in the 3rd year. So what can we do about this? De lege ferenda, it seems conceivable to promote repair by time limits and rules on evidence that are even more favorable to the consumer. However, I think the new rules raise the general question of the extent to which time limits and rules of evidence can really promote repair at all. And in addition, of course, the more fundamental question arises as to whether the consumer should not, as proposed in the original proposal, as if the consumer should not also be obliged to repair. Lastly, let me briefly mention other mechanisms of the repair directive. Article 4 provides that repairers must provide consumers with a European repair information form. Here too, no obligation is established. In the original proposal, such an obligation to provide the consumer with such a form was still planned for certain repairers, but this met with considerable resistance. So today it is a bit doubtful if this form will be really used, because of course it involves a lot of bureaucracy. Then Article 7 provides for the establishment of a European online platform for repairs. This mechanism seems reasonable as consumers usually obtain their information online today. But of course, the actually added value depends crucially on the specific design of the platform, especially its user-friendliness. And as already indicated, Article 13 of the Repair Directive stipulates that member states shall take at least one measure to promote repairs. These measures could be non-financial or financial natures. Examples are information campaigns or repair vouchers. Yes, and to wrap up, I will show you again the discussion points that we collected during the presentation. And I'm sure you have more questions and other questions that we can discuss. And I'm looking forward to our discussion, and I thank you very much, of course.
Thanks a lot for this third presentation. In the following, we will hear the presentations, the opportunity to hear the presentation of the two newest professors that works in the International Law Department, Professor Scaff, and after that, Professor Barcelos. Professor Tatiana Scaff, please feel free.
Good afternoon, everyone. It is a pleasure to be here at this event, talking about green consumption and how can we address these current issues that we are dealing with in our current society. Thank you, Professor Augusto, for the introduction. Thank you, Professor Claudia, for including me in the program. And it is a pleasure to be cited here with all of you. My talk today, it's about the arbitral clause in consumer contracts, a debate from Brazil and abroad. I first would like to say that the general idea that connects my lecture to the all of the other lectures that preceded me, and possibly with what Nicole will address later on, it's the green transition that we are inserted in and that we must carry on because of this current scenario that we are all inserted in, that we need actually to have new mechanisms to fight climate change and all of these problems that we have been dealing with recently, included here in Porto Alegre, where we have suffered from a devastating flood just a couple of months ago. So to talk about arbitration clauses and in consumer contracts and green transition, where do I stand on that? First, I would like to say that in Brazil, since 2006, we have been having a digitalization movement within our judiciary. So all of the suits that we once had in physical and paper, we are now having them transferred into electronic suit. So we do not have many more physical suits. We only have on digital processes that we have been carrying out. Indeed, since 2006, we should been carrying on this digitalization of processes until 2025. So we actually had this limit until next year to have all the suits digitalized. This is something that we have to think of because we are actually getting on 2025 and we do not have all of our suits still in a digital manner. So this is something we have to think on. But precisely this digitalization of suits comes to something that I would like to talk about. It's on the new methods that the new procedural code also inserted in our legislation, in the newest procedural code of 2015, which is also other methods of carrying out litigation, precisely alternative dispute resolution methods. We are now having something in our judicial system is that side by side on this digitalization procedure that we must carry out, we have been having a lot of suits in certain issues. For instance, the one that we have more suits in Brazil is on, in a civil matter, is on consumer law. So consumer law is responsible for the main judicialization in Brazil. And then we come to think that we need to have actually other methods of finding a solution, not only by the judicial proceedings. And in this way, the new Civil Procedure Code inserted a lot of mechanisms that we can actually have this disputes solved, such as through mediation, such as through conciliation, and such as arbitration is being a possibility. But then we come to think, is it possible to have arbitration within consumer contracts? And we all come to think about this consumer contracts. First, it is the most debated issue that we have in our judiciary. So second, we need to dejudicialize, meaning that we need to have less suits, or we have to have alternative sorts of dispute resolution. And on the other hand, we have this possibility of not only having mediation, conciliation, but also arbitration. The only thing that we have is that our consumer code prohibits arbitration, considering it abusive clause because of Article 51, letter 7 of our code. So we are not supposed to talk about arbitration within consumer contracts. Nevertheless, we also had a lot of tries of new laws being proposed in our Congress that wants actually to insert arbitration as a form of dispute in consumer problems. One of that happened in the same year that we had passed this new Civil Procedure Code, which is also from 2015. So in the very same year where we inserted in our judicial system that we must carry out alternative dispute resolutions in order to have less suits, in order to carry out maybe not only just a green transition, but also a more dialogue specimen of dispute resolution. And then we also had in this very same year proposed a law that would allow for arbitration in consumer contracts, which was at least finally and thankfully rejected by our Congress. So being rejected, it means that we could not use arbitration in consumer contracts. Still, if we come to our judicial system within the Superior Court of Justice, we still see some cases allowing for arbitration in consumer contracts. But if we read them closely, what the Superior Court of Justice poses is that we need to take a look on the vulnerability of the consumer. Being the consumer more vulnerable, we cannot allow for arbitration to happen. On the other hand, if the consumer is less vulnerable, we could allow arbitration to be taking place within the judicial system or carrying out as an alternative to the judicial system. But then it came to me something that we need to discuss, which is the problems and the perils of having arbitration within consumer contracts, specifically because of cases of click agreements. And I take the example of Disney World that you probably heard of, a recent case where a person died within a Disney World park because the person ate some food that she was allergic to. And she even told that to the people that were serving her within the restaurant, the waiters and so on. But she still died because of a shock, because of her allergies, right? And then her family sued Disney World, saying that they wanted this sum because of actually, she actually said, okay, I cannot eat this, I'm allergic to it. And Disney World did not comply with that, falling under consumer relation and falling under a possible case of civil responsibility. But then Disney World alleged something on their counter memorial saying that actually we cannot be sued in a civil court within the United States. We have to be sued in an arbitration tribunal. Because when you finally signed upon the Disney Plus channel, so Disney Plus, the streaming channel, not related to the consumption they had within the park, not related to the acquisition of an entrance to the park, Disney Plus. So they have to be brought before an arbitral tribunal. And the United States civil court said, yes, there is this clause, yes, you signed upon Disney Plus and said anything related between the parties would be taken to an arbitral tribunal. So then we have to think about these problems related to arbitration within consumer matters, within click agreements, especially now that is very popular because of the digitalization of the world as well. And then one question that we need to think about, is this something that only Disney World carries out? No, Walmart and Airbnb also have these clauses within their contracts. So if you actually rent some apartment through Airbnb, the clause says anything that happens within this consumer relation you are carrying out here, it has to be solved through an arbitral tribunal. And within Walmart as well, if you shop online through Walmart, you will have to be taken, if anything happens, to an arbitral tribunal. But then we have a lot of vulnerabilities regarding an arbitral court within a consumer matter that have to be taken into consideration. Not only the vulnerability of the consumer per se, of not having this possible contact with the contract, with the small lines of the contract, or knowing what he was signing upon when signing Disney Plus and entering on an amusement park, but specifically when it comes to digital vulnerability. So I would say that the main issue that we have to be considering nowadays when it comes to arbitration and consumer matters is digital vulnerability. Not only we have to consider the normal vulnerabilities consumers have, but we have to take into consideration the possibility of having access to an internet, possible because this arbitration could be held online. Not only that, the costs of arbitration, because costs of arbitration are normally divided upon the parties. And we have to have a knowledge of arbiters who can actually solve the issue. So how can a consumer appoint all of those, specifically when it comes, for instance, to a digital arbitration? And this is something we have been discussing, and we have been actually saying it would be a loss of consumer rights. And it is why, for instance, we have to hold upon Article 51, Letter 7 of the Brazilian Consumer Code, which prohibits arbitration for being inserted within consumer contracts in general. But we have to be aware that in a very connected world, sometimes we are not only dealing with problems related to a supermarket around the corner or an amusement park in another state here in Brazil. We're talking about signing upon Disney Plus, which I believe maybe 1/3 of the people here already sign upon and never realize that it would actually limit your right of fighting, for instance, for some rights that could be violated within an amusement park in a just a summer trip with your family. So these barriers of the digitalized world have to be taken into consideration when we discuss these arbitration possibilities for consumer contracts. And this is not something that, at least in Brazil, we are okay because of Article 51, Letter 7 of the Consumer Code. But this is something that would have to be discussed even abroad, possibly in a Mercosur agreement or even in a CGIP agreement under the OAS, because this is something that it is our near future, and this is a problem that we have to deal with in our day-to-day basis. So I would say that although the green transition is positive, although the digitalization of suits, or even considering the alternative dispute resolutions as being all positive, we cannot deny there are certain rights and a hard core that cannot be broken because of this digitalization of consumer relations that we are now having throughout the world. So I wanted to talk a little bit about this and these problems, and I guess I passed the message. Thank you very much for your kind attention.
Thanks a lot, Tatiana. And now we are going to the final presentation from Nicole Rinaldi de Barcelos. Please.
Thank you. O teclado, por favor. O teclado. Isso, para passar. Thank you, Professor Jäger Jr. Good afternoon, everyone. It is a pleasure to be here today with all of you, especially in a panel presided by my Dr. Fata, with whom I learned so much about German law and also US law. And I must say that today has been incredibly fruitful and inspirational. And I would like to thank you, Professor Cláudia Lima Marques, for organizing, and Professor Beate Gesell also for organizing such a wonderful event, and all of the professors who taught us so much so far. Caio will open my presentation. Just a moment, please. Eu acho que está em outro, é do Canva. Eu acho que está num... Já estava salvo em algum lugar, só não sei. Mas ele abriu, tá? Ele abriu aí. Estava salvo em algum lugar. Quer que eu te mande o link? Não tem problema, só deixa eu achar aqui. Vou te mandar no WhatsApp, tá? Just a moment, please. I will start speaking and then Kai will open. So consumer relations often cross national borders and extend to international spheres and regional spheres, forming a global network that presents challenges for private international law. And this is a very practical problem. As Professor Claudia Lima Marques emphasizes, consumer protection should not be privileged only because the consumer is a relevant economic actor. But in international markets, the consumer is also a symbol of globalization. Paradoxically, despite the consumer plays a relevant role and a social role, consumer suffers from a special vulnerability inherent to the internationalization of the relations they developed in global arena with the sellers, especially in digital markets. In this context, a pressing issue in contemporary international civil procedure law is the consumer's choice of forum, which occurs when the parties of a contract agree on choice of forum clause. So this will be the subject of this presentation, and this exposition is divided into 3 parts. The first one, I will talk a little about, and I will propose a brief discussion about international jurisdiction and consumer protection fora. In the second part, I will analyze the choice of forum itself, and the consumer protection as well. And in the third part, I will approach the choice of forum in Brazilian consumer law in the light of recent changes in the Brazilian Code of Civil Procedure and case law. Thank you, Caio. So here, acho que não passa. Em alguma, não tem na pasta de download, será? Ah, vai? Tá. So here's the agenda for today, and I will make then concluding remarks about hope for the effective access to justice for consumers. Não está passando. Passo para o terceiro. Obrigada. So, in consumer law, the provision of legal norms that favor the weaker party, or as we call favor debilis, are at the core of the entire consumer protection system with reflections in private international law. In fact, private international law is undergoing a methodological revolution in which the discipline becomes open to legal material value judgments. And as such, it is no longer possible to ignore constitutionally anchored principles such as access to justice, equality, and human dignity. Legal norms then assumes the function of promoting equality when a disparity of forces between the plaintiff and the defendant is identified, favoring the weaker party. This protection has a strong justification. The reduction of barriers to international trade, the digital economy, and mass tourism have made the global citizen also a global consumer. In the field of international jurisdiction, Dario Moura Vicente emphasizes that the obligation of the consumer to pursue a claim in a country different from their domicile accentuates their position of weakness in a relation to the supplier. For this reason, protective jurisdictional criteria for the weaker party arise, providing the possibility of filing claims in the consumer's domicile or forum actores, as it is the case of the Brazilian Code of Civil Procedure, Article 22, Section 2, as well as in the Brussels I reformulated regulation in the European Union. That said, we can say about this part, and Caio, you can go ahead, thank you, that the rules that determine that the domicile or habitual residence of the weaker part in the consumer relationship are known as protective jurisdictional criteria and aim to ensure access to justice for vulnerable parties by correcting existing asymmetries. And this should be the core and should be the fundamentals of a choice of forum analysis, now choice of forum clause analysis when it is interpreted by our tribunals. So I go now to the second part of this presentation, where I speak about the choice of forum clause and the consumer protection. Thank you, Caio. According to Eric Jamie, the protection of human beings in the face of globalization involves strengthening the autonomy of the will, or party autonomy, through the possibility of choosing the competent forum by the parties. And this is a discussion that has gained traction in contemporary private international law, especially regarding the effects of these clauses in disagreements. As Professor Tatiana has said today, many consumer contracts, adhesion contracts come with these clauses, and the consumer has no liberty to discuss, no freedom to discuss these clauses. So a forum selection clause or a choice of forum clause is an agreement between contracting parties to litigate their dispute in a pre-selected forum. This means that a forum selection clause is a contractual provision that selects a specific forum or a specific court to resolve disputes. Such a clause in terms of, functions in terms of both prorogation of jurisdiction by conferring jurisdiction to a forum chosen by the parties, and derogation by precluding the other fora which might be competent courts from a certain jurisdiction. In a standard situation, the contract is a product of negotiation between two parts, two businesses. This approach has long been applied in international commercial transactions. But we have to question, is it possible to have choice of forum clauses in consumer contracts? When it comes to consumer contracts, the approach should be different. The inequality of bargaining power and the vulnerability of the consumer means that the consumer contract is usually a standardized contract or adhesion contract, as we say in Portuguese, né? Contrato de adesão, with the choice of forum clause unilaterally inserted by the businesses. And the consumer is in a position that we say that it is a take it or leave it position. In these situations, the autonomy of the consumer's will, the party autonomy, is limited since they do not have the opportunity to discuss the contractual clauses that provide for the choice of forum. For this reason, many states have specific norms and rules to restrict the effect of these clauses, and the Hague Conference on Private International Law has expressly excluded consumer contracts from the scope of the Convention on exclusive choice of court agreements. So now we move to the third part of the presentation, where we speak about how Brazilian law approaches consumer. Alô, agora sim. So Brazilian law has enshrined the autonomy of the parties in choosing international jurisdiction in the Brazilian Code of Civil Procedure of 2015. According to Article 22, national jurisdiction is established in cases where the parties expressly submit themselves to national jurisdiction. And this article is complemented by Article 25, which states that there is no Brazilian jurisdiction when there is an exclusive forum selection clause in an international contract. although the Brazilian Code of Civil Procedure has expressly enshrined the possibility of choosing a foreign forum, this provision should not be applied to international consumer contracts that are adhesion contracts, in order to avoid any provision that could violate the consumer's rights and violate the rights of the vulnerable parties. Which we should say, if in one hand the foreign selection clauses are desirable, and it is a desirable recognition of the autonomy of the parties, on the other hand, when it comes to consumer contracts, this analysis must be made in a dialogue of sources with the Brazilian Consumer Protection Code, which provides in Article 6, Section 8, that the consumer has guaranteed and facilitated his defense, the defense of their rights, and also Article 51, Section 1, that allows the judge to declare no clauses deemed abusive. And this should happen when there is an abusive choice of forum clause. The Brazilian law, therefore, directed towards the declaration of nullity of the choice of forum clause upon demonstrating a restriction to the right of defense and access to justice. Pode ir adiante. Now we go to a recent case law. First of all, I should say a brief word about the recent changes in choice of forum in Brazilian law. In 2024, we had some amendments in our Brazilian Code of Civil Procedure regarding the choice of forum clause. And there we have, in Article 63, paragraph 1, we have that the choice of forum only takes effect in a written document, and that expressly alludes to a legal transaction and is relevant to the domicile or residence of one of the parties. But this provision expressly accepts the consumer agreements when it is favorable to the consumer. So therefore, regardless of the merits of the reform, because this reform has been largely criticized by doctrine, in regard to consumer contracts, it provides that the most favorable law to consumers should be applied, which is desirable. And now, as we go here, you can adiante. Volta, isso, volta. Mais para frente agora. Aí, beleza. So now we go to an example, recent case law in Brazil, which applied the Brazilian Code of Civil Procedure, a case of 2023, where the Superior Court of Justice ruled that the Brazilian judiciary has jurisdiction to process and judge a case involving the termination of a hotel service contract entered into force in Mexico for the purpose of producing effects there. So the court decided that the case could proceed in Brazilian courts, so Brazil had jurisdiction in this case, because the contractually chosen forum abroad hinders the existence of consumers' rights who resides in Brazil. So the contract had a clause, a forum selection clause, that said that the contract should be processed in Mexico, but Brazilian Superior Court of Justice said that because we have this jurisdiction in Brazil and the application of this contractually chosen forum should hinder consumers' rights, this case should be processed and should be tried in Brazil. So with all this in mind, I should say at this point that German scholar Jan Kropholer, since his seminal study in international procedural law, already emphasized that the jurisdictional criteria established by the state should be guided by the aim of protecting substantive legal interests of the parties. According to the author, the duty of contemporary legal system is, above all, to find a fair balance between interests of the parties and protecting also the rights to defense and access to justice. In conclusion, the procedural protection of vulnerable parties play a central role in contemporary private international law, as it constitutes an instrument for the realization of material rights of the international consumer. So every procedure rule should be applied in the light of a dialogical interpretation that considers consumer protection code and other protective norms. And now we move to the final remarks, thank you, which I called towards effective access to justice to consumers. And I always like to make relations with art and the aesthetics of arts, because I believe that art and law have this close connection in their culture and their production of human spirit. So I always look at this ballerina from Edgar Degas, which is in São Paulo, in Museum of Art of São Paulo. And I have always interpreted this sculpture and consider it a symbol of a delicacy, like the ballerina. But however, and I have never before noticed that, when I came into, when I got in touch with the incredible work of the photographer, Brazilian photographer, Sofia Borges, I saw the face of the ballerina, which I had not noticed before. And this made me have some thoughts about how things are not as they seem to be. And I started to think, relating to law and related to this topic of the discussion, we can say that the consumer, much like a child, and the child is also protected for different reasons, obviously, but it is also vulnerable. The consumer must be protected, and we should go beyond appearances, you should go to the substance of the protection of the consumers. And I believe that is all we have seen today from everyone who made these presentations today. The persons are beyond normative provisions, and we should be aware of that when we speak about changing provisions or interpreting provisions by the courts. So legal systems should go beyond what appears to be and touch the substance to promote effective protection of consumers, protection of people. And this should be the goal of interpretation of choice of forum clauses to promote access to justice. Thank you. At the end, it is my email, and I'm looking forward to the discussions.
Thanks a lot for all the presentations. And I have an ask question now. We make a break now. Okay, we can discuss and just to inform. Yeah. Yeah. Well, we make the discussion and inform that there is coffee and cakes and cakes in the Alberto Pasqualini room in this floor. Yeah? After in front of the stairs. Okay.
Others will be very sad if we don't take coffee that she prepared. We go. Yes.
Yeah. Okay. We made a break.
6 minutes.
6 minutes. Okay. Thank you. Thank you.
to be at this table. And I thank you for the invitation to this debate. I'd like to start by commending our previous speakers for their important insights and thought-provoking speeches. The topics discussed before are essential as they highlight the interconnected goals of consumer rights, environmental responsibility, and access to justice that shape a sustainable marketplace globally. Today, I'd like to briefly explore how artificial intelligence can support these goals and foster sustainable consumption, focusing on 4 key areas: transparency, compliance, consumer education, and policy support. AI brings unique possibilities to promote transparency. It allows us to track products throughout their life cycle from raw materials to disposal, giving consumers clear information on environmental impact, labor practice, and carbon footprint. This visibility empowers consumers to make informed, sustainable choices and can set the stage for future regulations on product information disclosure. Next, in compliance with sustainability regulations, AI can help companies keep pace with rapidly changing laws worldwide by providing real-time updates on legal requirements. AI ensures that companies can quickly adapt to new rules, avoid penalties, and align their practice with sustainability goals. This also builds trust and shows a genuine commitment to environmental and consumer standards. When it comes to education consumers, AI tools, chatbots, and virtual assistants can inform people about the origins, impacts, and sustainable alternatives of products. With better information, consumers can make choices that reflect their values and support a sustainable future, aligning with the right to accurate information protected by many consumer laws. Finally, in policy development, AI can help identify areas where sustainable practice need incentives. Analyzing data, AI can highlight which products or practice warrants support, allowing governments to design policies like tax breaks or subsidies that encourage greener production and consumption. In conclusion, AI has powerful potential to advance sustainable consumption by promoting transparency, supporting regulatory compliance, informing consumers, and aiding in policy development. As legal professional, endorsing the ethical use for AI in this area enable us to contribute to a future grounded in environmental stewardship and respect for consumer rights. For the end, I would like to ask the professors a question. What alternatives could be implemented in an international forum to ensure the application of the best consumer rights? Professor Tatiana or Denise? Thank you.
Thank you, Fabiana. This is a $1 million question, I believe. We have today, I think, a lack of an international forum with how can I say, binding resolution or treaty in international fora, I believe we do not have and we should have. But consumer law is a sensitive theme, and I believe that countries have different views of consumer protection. Here today we saw that German law and Brazilian law have much in common. And as we study, we know that European Union law has so much in common with Brazilian law. But if we go to countries of common law, I believe the views of consumer protection is different, as well as the views of the intervention of the that the state can make in the markets, as well as competition law. So I believe this fora that like ASAGIP or CGIPs from American Association, they provide interesting mechanisms that are not binding but inspire inspire norms inside the states. For example, today I didn't speak, but I had in mind, I had actually in my presentation, and the time was so little, I took off. ASAGIP has Transjus principles on access to justice, which is not a binding document, but it's a great inspiration for every country and American countries to how can I say, design norms inside the countries. So, and it has consumer provisions, like the most beneficial law to consumers. So maybe the path to follow is this at this moment, because I believe that multilateral treaty, we have not achieved yet. Even if us, like scholars, students of consumer law, we have still a hope that this could happen. So someday, and we will work for that. So it's not an answer, but I believe it's some way to think.
Thank you.
Muito obrigado. Acho que podemos seguir o debate. Can we follow the discussion? Anyone has a question?
First of all, I want to thank this beautiful group of papers and conference, and really very inspired. And I was struck by how deep goes the Green Deal in Europe. But my question will be for the Brazilian colleagues. Sorry for that. It's about the reform of the Brazilian code, and the reform focus on prevention and treatment of over-indebtedness, but had what you say, a null and void clause in the list of Article 51 of our consumer code. And this new Article 51 number, what is the number here? Number 17 say that is void clauses that state a condition or a limit in any way the access to the judicial system. So Professor Tatiana Skeff spoke about arbitration, and Professor Barcelos spoke about the choice of court. And I did not see any mention or yet in the judiciary about this, but I heard about new studies from our Conselho Nacional da Justiça, CNJ, our Judiciary Council, National Council of all judges, that spoke about like barriers to the consumers to access the judicial system that you need before go to administrative agency like Procon, or make something direct claim to the provider before you go to the justice. So I think one side we changed our consumer code, but in the other side it did not seem very effective or very known, this new number in our void and null clause list. So I want to ask what you think is the problem now, because the judges are overwhelmed with so much consumer claims. They want to have a solution for that, or the consumer code itself has less power at the moment. It's just a question, a reflection, because I know that there are no answer because of this, but it not seems very effective.
So indeed, something that the judiciary now has been dealing with, and it was the focus of even Brasil-Con during this event that they held, I think a month ago, regarding a decision of judges that now they suspended the suits in order for first trying to solve issues through an alternative method of dispute resolution. And therefore, if nothing is done, and then we come back to the suit. But this is something that has been done now in Minas Gerais very openly, but also in Mato Grosso do Sul and Mato Grosso. Therefore, other Brazilian states have also been doing that for at least 5 years. And this is something that really becomes a prejudice in terms of consumer relations and consumer protection, because it disconsiders the very basics of the Consumer Protection Code, which establishes not only the access to justice as a right for the consumer, but also in terms of disregarding its vulnerabilities. And one of the vulnerabilities is also having not to go through a process of an alternative dispute resolution, for instance, without him or her wanting to. So I would say that the project does not solve the issue, as you mentioned, but there is nothing we can do in order to make it more effective if the justice system does not see the vulnerability of the consumer and considers it as the way it should. I think the very problem is the judiciary and not the codes or the laws we have. But still, now the National School of Judges that we have in them, they have been focusing on studies regarding alternative dispute resolutions or multi-door justice and other sorts, not specifically arbitration. I'm not saying that. I'm saying mediation, conciliation, and other forms in order to try to judicialize the system, which is something that is positive if we come to think about Sejuski and other forms of trying to come to a solution and not having the suit that sometimes takes 2 years and sometimes take 10 years in order to have a decision. So I would say the judiciary is the problem.
So first of all, I'd like to thank all of you very warmly for your very inspiring, wonderful presentations. Thanks a lot. I also have a question for Tatjana. Actually, this arbitration clause, or arbitration clauses in consumer contracts issue is really, I think, an important topic. And I don't know whether you know that in the European directive, the European ADR directive dating from 2013, there you find in Article 10, paragraph 1, you find a disposition which bans, which kind of prohibits the insertion of such arbitration clauses in consumer contracts beforehand. You can, after once the problem is known, is that the consumer is conscious to the problem, then of course he can agree to to do arbitration, but not beforehand. And therefore, I just double-checked the Airbnb adhesion contract terms, and so for Europe, for users living in Europe, the right to go to court, access to court cannot be excluded. And what I'd like to know, if there are similar ideas in Brazil to set up such a law, just blocking this kind of clauses. And I'm still a little angry about the U.S. Supreme Court, because I mean arbitration normally in consumer U.S. American arbitration does not make US-American style arbitration does not make much sense in consumer consumer disputes, because it's too expensive. But the reason they do insert these clauses is because they want to ban collective redress, and the U.S. Supreme Court said this is okay, this is valid. You can, by way of beforehand choosing arbitration, exclude collective redress. And so I'd just like to know what is the Brazilian opinion on, because there's also much critique to that in the U.S. context.
So within Brazilian legal system, we do have our law that prohibits arbitration, consumer arbitration clauses, which is the Consumer Arbitration Code. Article 51 prohibits it. Indeed, there are several projects and laws trying to be enacted that would end it, but so far we did not have any laws succeeding to overcome the prohibition for consumer arbitration. But what we do have, nevertheless, is that the Superior Court of Justice, it does not disconsider arbitration every time it comes to court. So it depends on the vulnerability of the consumer. Unfortunately, for the Brazilian Superior Court of Justice, it depends on the proof that you have of vulnerability of the consumer in order for the arbitration to be considered or not. Of course, it depends on whether you have proposed arbitration after the problem happened, so never before. So this would be considered null. That's what the Article 51 of the Consumer Code establishes. Nevertheless, when we have after the problem has happened and then somebody says, maybe we should take it to arbitration, and it depends on the vulnerability of the consumer. So it will be assessed by the Superior Court of Justice in order for it to be either upheld or disregarded in terms of having this clause being put forward, right? But yes, the EU ADR system prohibits it in order to have the access to justice right really upheld. We do have a similar prescription in our constitution that would actually says that in any case, we cannot have the justice system put apart because of a condition. It is actually a constitutional clause, so it could not be just disregarded by the Superior Court of Justice, but it does because of the vulnerability, because it says that the consumer code is based on vulnerability, and if we do not see vulnerability, we do not apply that to a consumer relation. So this would be the aspect. But that's why I mentioned at the end of my talk that maybe this is something that we should be discussing in terms of a Mercosur agreement or even in a CGIP under the OAS. I think maybe this could be a debate to be held. We're going to be having an OAS is a GIP meeting next year in August in Rio de Janeiro. So maybe this could be something that could be brought up into this discussion. So we even had a meeting today on ASAGIP regarding issues that could be debated at. I can definitely suggest this as being a topic.
Just to add something about this very good response from answer from Professor Tatiana Skeff, that the Bill 3514 that aim to update the consumer code has also a ban of arbitration clause, a very clause ban, because this solution from the Supreme Court is very, very difficult in the end. No? So we try to have a ban, but it's not yet in force. So thank you very much, Tatiana.
Thank you. I have a question to Mrs. Meyerhofer and the directive to repair products. Have you already considered it from a law and economic point of view? Are this rule efficient if you take the Pareto approach that you like to create rules that create the most benefit for the society? Because take two examples. First, a car that becomes older and older, gets an old timer, and the duty of the producer to offer products to repair the car. At the moment, we have BMW and Mercedes. Mercedes has a very generous policy to keep spots and places to repair the car for 40, 30, 50 years. So old timers are very popular if you have Mercedes. In contrast, BMW don't do it. Here the market decides which company you should prefer. If you make a rule that says you must offer places to repair the product for a couple of times, then it's the lawmaker or the justice or the courts who decide who is an appropriate amount of time, what are appropriate costs which exist. So my question is, should the market decide the questions how long you offer the product or not? But it's the first example, and the second example is the washing machine that you already mentioned. You know, Miele, that are very famous washing machines who are good for 10, 15 years because they have better elements in the machine, so they are good much, much longer than an ordinary machine. Yeah. So if you also take the market, you find washing machines who are very cheap, but who are good only for 2 years and then they collapse. And on the other hand, you have the Miele who costs perhaps double or triple the price, but runs for 15 years. But still, it's the consumer who can decide, do I have a lot of money to buy a long-running machine, or do I only have the money to buy a good that it's good only for 1 or 2 years? If now the lawmaker create a rule, the duty to repair the product, then you must also take the cheap washing machine, yeah, and add this additional legal duties that at the final end add additional costs. So my short question is, why is the lawmaker cleverer than the market itself, yeah, to decide what kind of products should be offered to the consumer, especially if you have poorer consumers, richer consumers, yeah, to make the difference between the right, appropriate product they like to offer.
Thank you very much. I'm actually not sure if the economic analysis does work in this context of sustainability regulation, because our goal is not only to achieve the, I don't know, most efficient result to lower the cost, but our goal is to achieve more sustainability. I think it would work if you could like translate the sustainability goal into costs. If consumers would really be willing to pay more for a more sustainable service, product, I don't know. And I don't think that is already the case. Like we have seen, consumers are sustainable conscious. They want to like do something for the environment, but if the costs are too high, they won't do it. So I think if our goal is to achieve more sustainability, we cannot only rely on the economic analysis, on incentives, on the Pareto optimum.
But shouldn't you create a rule that create a better product? Because if you just have an indirect rule, the duty to repair, you have this cheap washing machine. I had this example that my washing machine only ran for 2 years, and exactly after 2 years and 2 months it collapsed, yeah, because there had been weak parts in the machine, yeah. And so you have this additional repairing costs, yeah, the transaction costs, yeah. So if you try to reach your goal, substantiability, yeah, I think it would be best world and also the most efficient solution, yeah, to create a washing machine who will not collapse after 2 years and 2 months. And so the rule shouldn't, I think the directive, yeah, creates indirect duties, yeah, to fulfill the goal of substantiability, but they are more expensive than creating the better product, yeah, that runs for a longer time so that you don't have to repair it. And then very often you have plastic instead of steel, yeah, in the products, yeah. So you have this short run, yeah, production. So the duty of repair, okay, take a poor product, yeah, and try to make it years by years, longer life period by repairing it. But it would be still better, yeah. Take also the clothes, yeah. If you can buy clothes, yeah, that you can wash twice and then you can throw it away, yeah. Wouldn't it be better, yeah, to create clothes, yeah, or perhaps forbid clothes, yeah, or creating additional costs to clothes, yeah, that you can wear for perhaps 2 years, 5 years, 8 years. I'm having clothes I'm wearing for 20 years, yeah. Why not, yeah? Why should you? And with clothes, I think it's quite hard to repair them, yeah. And here also your rule, yeah, if you take push T-shirt, yeah, with products that you can buy for 1, 2, 3 euros, yeah, they're being produced in Pakistan, yeah, and they are with low products, yeah. There, I think this duty of repair is quite hard to enforce.
Yeah, I think the problem is what is a better product? Like, will the consumer take this possibility to have it for a longer time into account, or will the consumer say, okay, I have it, it's cheaper, I have it for 2 years, and when I buy a new washing machine, this may be like cheaper for the consumer, and in the end, it may be the better solution because the consumer once has a washing machine for 2 years and then a new washing machine for another 2 years. So in the end, maybe the more attractive solution. So I don't know if the market is able to reach these sustainability goals.
But the question is of this directive will will reach the goal. Yeah, because the duty to repair, yeah, at this costs, yeah, with transaction costs, and just take the example of this poor product with poor washing machine, yeah, where perhaps you shouldn't construe such a product.
Okay, but that's a different question, I think. If the directive is able to solve all these problems, I just wanted to say that I think just the economic analysis is not enough in this context of sustainability regulation.
And there is perhaps one misunderstanding, since the right to repair must be paid for by the consumer.
Yes.
So it's not that the manufacturer has to require a higher price. So you have to pay for it, and you would probably not, as a consumer, require carry out this right to repair if it's a cheap product and it doesn't make sense because it's too expensive. But I agree with you that this is only, I mean, it's kind of, it's one idea, right? To repair sounds good, but I mean, there would be a very, 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 very easy solution, and that is doing away with prescription. Doing away with prescription, then that would really lead to sustainable production.
Mm-hmm.
And Catherine.
I would like to add something to Ann-Christine Meyerhofer's presentation. You were wondering if the consumer would even know if something happens within or without liability. And the EMCO directive I was talking about addresses this issue in a way that I'd like to just add. So I was talking about these pre-contractual information requirements, and one of them is that that the consumer must be reminded of the existence of legal guarantees of conformity for goods and its main elements, and it also needs to inform about the minimum duration of 2 years. And the directive considers this essential because she promotes this, and this information, unless other information, must be presented in a, I quote, prominent manner and using a harmonized notice. The Commission is working on this harmonization. So still, we don't know if the consumer knows it, but the Commission is trying to address this, that the consumer at least can retrieve this information even more easily than other informations. I just wanted to add this aspect.
Thank you. I think that the easy case is that the liability period has elapsed when the consumer will be able to distinguish. The problem is the consumer has a washing machine and the washing machine stops washing. And the consumer will maybe not know, well, maybe I did not handle it that carefully, maybe it's my fault. And I think this is a different problem. You're completely right, and this is definitely a good idea to better inform. But at that moment, the consumer, even if the consumer knows that there are rights under the Sale of Goods Directive, the consumer will not know is it a lack of conformity or it is not a lack of conformity. That's more the problem. Actually, I have difficulties when judging how big this problem really is. I'm not sure about this, but I think it could at least be a difficulty.
Well, no.
I have just a theoretical question, because it's to Dr. Meyerhoff and Dia and Catherine, is about this Green Deal. I don't know if everything is obligation. I must say in German, Pflicht, or they are more I don't know, nudge, or they are another word in German, Obliegenheit. Kennt ihr das, Obliegenheit? This is not obligation, but something more than a nudge or a push for something. So I just will be curious if you see these new European directives or regulations going for this idea that if you don't do this, you will be in the future a penalty. This is the idea of Obliegenheit. No? It's not a Pflicht, but you can have something bad for you arriving later. No? And I don't know really the three directives that you spoke, but my question is if you can see this similarity, or it's really more really European and has nothing to do with this.
I think it's currently like a mixture. You have seen these 4 conditions for repair to be carried out. So like the good must be repairable. There are some regulations or delegated rules that force the manufacturer to construct the good in a way that the good is repairable. So it's a duty and obligation. And also these information obligations are real duties, obligations. And there's an obligation to repair, but on the consumer side, we are more working with incentives because we do not want to have additional duties for the consumer. We don't want to force the consumer to do a repair instead of a replacement. It was an idea at the beginning when the repair directive was first discussed to have a duty also for the consumer, but where it's more with like nudges. I'm not sure if you could call these nudges Obliegenheit. I think it doesn't really matter, actually. Yeah. Maybe you want to add?
So in the case of these obligation to provide software updates, we actually have both of this. If you want to reach the goal to prolong the life cycle, for example, of a good with digital elements, of course, it only works if the update is actually installed. And as I told you, we do have the obligation to provide software updates, but it's not a forced installation. So from the consumer perspective, we have this Obliegenheit, which is, I think, more than a nudge, because the consumer can choose not to install the update and therefore not prolong the life cycle eventually. But then the trader won't be liable for anything that happens because he didn't install the update, given the instructions were clear and everything. So we have, I would agree, there's a mixture on this stuff. And from the consumer sides, it's probably not usual to work with obligations, but we do have this Obliegenheit, which I don't know in English exactly. I think it's more than a nudge in that case, but yeah.
Thank you a lot. I think it's the time to finish the discussion. We will have classes in this room in the next. So it was to me an honor to be the president of this panel and would like to thank this workshop, the given opportunity that young women researchers can speak about their subjects among around the well-known around the world ordinarius professors from German and Argentinian. Thank you so much. Sie wohnen in München.